us to vote down or block secondary legislation. Those rare circumstances, I would argue, do not include this situation, a situation in which noble lords are seeking to challenge the House of Commons on a matter of public spending and taxation. And that was the point made very effectively by the noble Lord Butler. The sums involved are not trivial. The regulations before us, as I've said, would account for welfare savings of 4.4 billion in 2016-17. We can argue, my lords, I'm actually quite interested in arguing, but I don't think it would be profitable, about the technicality of whether these regulations are or are not financial. But in substance, they are very definitely and very obviously financial, and I would therefore say to the noble Baroness Lady Mansour that her fatally worded amendment should not be put to a vote. As regards the amendments tabled by the noble Baronesses Lady Meacher and Lady Hollis, the situation I would contend is simple. There is a choice before this House, either to approve or not to approve these regulations. It is a binary choice. The noble Baronesses are inviting the House to withhold our approval. We can argue endlessly, once again, about the technicality of whether the wording of these amendments is or is not fatal in nature. But the reality is that if either amendment were passed, this House would not have approved these regulations. And it is no good saying that this would merely amount to asking the House of Commons to think again. They can do that with Lords' amendments to primary legislation, but with secondary legislation, there is no mechanism for a dialogue between the Houses and no mechanism to allow the will of the Commons to prevail in respect of this instrument.
I apologise to noble lords. I sense he's coming to a conclusion. Does he accept that the amendment from the noble Lady Baroness Hollis doesn't ask the House of Commons to think again? It asks the government to reconsider its proposals and bring back new ones. It's asking the government to reconsider.
Of course, I do accept that. The noble Baroness's amendment is expressly asking the government to do something other than what is in the regulations. By definition, that means that if her amendment were carried, we could not bring back the same set of proposals. Implementation of these regulations would not be delayed, as the noble Baroness is suggesting. It would be thwarted entirely. So she's asking the House to accept a false proposition. And it is very interesting that the noble Baroness herself has recently given an interview which certainly implies that the noble Baroness Lady Hollis's amendment is a fatal one. The interview she gave to the Huffington Post. She said in that interview that if the noble Baroness's amendment were carried, it would mean that the government couldn't go ahead with the cuts. Well, that to me is very fatal indeed. My lords, therefore,
really quite surprised at the noble Earl, with all his experience and the respect that he's held in this House. He seems to be suggesting that there is no significant difference between a fatal amendment and a non-fatal amendment, which in the time that I've been here, which is less than his, has always been an absolutely, a binary, I think was the word he used in another context, a quite clear distinction, which the leader of the House seemed to be unclear about in her initial presentation, that there's no distinction between the Lib Dem amendment and the Labour amendment. The difference is surely fundamental, and if he doesn't accept my proposition on this, can he at least enlighten the House as to what the professional advice from clerks has been to him and to the Conservative front bench as to which of these amendments are fatal and which are not?
There's a clear difference in the wording, and that is unarguable, but the effect is exactly the same. That is the point I'm making.